Stacy Lipton. I'm the director of the Professional Advisory Committee at the Jacobson Jewish Community Foundation, and I'm so glad to welcome you to our virtual program, Get Your Docs in a Row, Estate Planning 101, on behalf of the Jewish Federation of South Palm Beach County. Our virtual programs are among the many ways Federation is reaching out to bring our community together as we also work to meet critical needs for our people here in Israel and beyond. I know some of you are involved with our Federation while others are less familiar. After our program, we'll email you some information about how to learn more about us and other ways to connect virtually with our Jewish community. The Jewish Federation of South Palm Beach County's annual campaign funds more than 70 partner agencies locally in Israel and around the world and enables us to respond immediately in times like these. Our agencies responding on the front lines of the COVID-19 crisis have been able to continue their work uninterrupted with the full support of our Federation. If you would like to learn more or would like to make a donation to support our vital work, please reach out to us at 561-852-3100 or online at jewishboca.org/donate. We will also provide this link at the end of the program. Before we get started with our program, I have a few housekeeping notes. We're muted for the presentation, but you will have the ability to ask questions at the end. We will have time for Q&A after, when you will be able to raise your hand virtually by clicking on the participants button and then clicking on the raise hand icon, and then you will be called on to ask your question. Also, you have control of the way your screen appears. If you would like to view the person who is speaking or asking the question, please select Speaker View at the top of the screen. Today, we're delighted to be joined by Josh Goldglantz. Josh is an attorney, board certified in wills, trusts, and estates with the Gunster law firm in Boca Raton. Josh concentrates his practice in the areas of tax, estate planning, and asset protection planning. He is a member of the Jacobson Jewish Community Foundation's Professional Advisory Committee and a 2020 graduate of PAC University. Josh, the screen is all yours.
Okay, great. Thanks, Stacy, and thanks, everyone. I will be sharing my screen. 1 second here so that I can get the PowerPoint up. Okay, so I think everyone should see that, hopefully. Thanks everyone again for joining us here today for this discussion in this new normal, if you will. Certainly this is a first for me. I've never given a presentation where I can see myself looking back at me in a presentation. I know we're all, I'm at home, and I know I think we all are as well. And I know there's a lot of funny viral videos that have gone around of people giving presentations or having work calls from home. I have 2 daughters under the age of 4, so hopefully neither of them run in here dressed as Elsa from Frozen and start singing so that we don't go viral. But thanks again for joining us today. We thought this was a timely topic to discuss getting your docs in a row. This will really be estate planning 101. We're just going to really cover the basics of estate planning here, give a little refresher. As an estate planner, we have really seen, we've been very busy over the last month or two with everything going on. And I think that's for a couple of reasons. One, people now have time to get organized. As they're home, they have time to revisit their estate plan, get to things that are on their proverbial to-do list. So we have a number of people that have always had implementing an estate plan on their to-do list or updating their estate plan on their to-do list, and they're really now getting to it and focusing on it. So this is a good time to revisit the basics. You know, a lot of times people come to us to revisit their estate plan because there have been changes in finances, changes in family situations, changes in the law. So those clients are coming to us to revisit a plan that's currently in place. And then there's a lot of new clients that are coming to us given the circumstances, given everything going on, to make sure that they have their estate planning documents in a row. And particularly, which we'll get into, certain healthcare surrogate designations, what happens if you're hospitalized, who can make medical decisions for you, who can take care of you, things like that. So we'll start here. Let me scroll down. Okay, so today, what are we going to talk about today? The topics for discussion. One, and which we'll spend most of our time really, will be what I call the basics, the typical package that you see today: wills, revocable trusts, durable powers of attorney, healthcare surrogate designation, and living wills. You can call those the big 5. or something like that, or the Fab Five, but those are really the main documents that we'll spend the bulk of our presentation on today. We'll also talk about the importance of revisiting beneficiary designations. It's so important to check beneficiary designations, and we'll talk about it, but it's one of the most common mistakes is not updating beneficiary designations to be consistent with your estate plan, with your will, and with your trust. Also, we'll talk briefly toward the end, time permitting, about the Secure Act and charitable planning. So the Secure Act went into effect at the end of 2019. It was part of a massive budget bill signed by President Trump at the end of December, which had 1.7 trillion in spending. And in part of it, in the budget, it was partly paid for by accelerating certain retirement plan benefits and how they're taxed for beneficiaries. And so the Secure Act was a big change for retirement plans, for 401ks, for IRAs, and how you designate beneficiaries. So we'll talk about that. And then also some charitable planning. And we'll talk about some of the good things that the Federation is doing and why charities are so important now, given everything going on. So let's start really with the basics. So wills. Estate planning today really does differ significantly from the traditional estate plans that your parents or grandparents may have implemented. Today we have assets are much more complex and varied. Technology has changed the way that we live, that we do estate planning, and that how we administer assets. And so one of the main differences in estate planning now, as opposed to 20, 30 years ago, is the use of revocable trusts. And so there's they're commonly referred to as revocable trusts or living trusts or revocable living trusts or any iteration like that. But really, traditionally, the main dispositive document of one's estate plan used to be just a will. Now, we have a will and a revocable trust. And that's where we call these wills pour-over wills. I will tell you that over 99% of the clients that we work on and the estate plans that we do utilize a pour-over will and a revocable trust. And so what does that mean? Whereas historically, the will was the main dispositive document. The will is the document that disposes of your assets, has your wishes, who your beneficiaries are, how your assets get distributed. Now the main dispositive document is the revocable trust. And what a pour-over will is essentially just that. The will is simpler, and the will essentially says, all of my assets pour into my trust. So the trust is the beneficiary of the will. And we'll go through that, and there's a number of reasons for that, the probate process being one of them in avoiding probate. But even if you have a revocable trust, you need a will. They work in conjunction together. So you still always need a will. And so two of the main considerations that we bring to clients when they come to us to talk about a will are, one, who would they want to name as their personal representative? The will appoints a personal representative. This is the person that administers your estate, that collects your assets, contacts the beneficiaries, deals with the court, goes through the probate court process, which I'll talk about shortly. But the personal representative is the person that you trust to marshal your assets, collect your assets, and distribute them. Now, things have changed significantly in the way that works because historically, when someone passed away, your personal representative or the attorney would say, collect that person's mail for a month or so, and then you would have an idea of what assets they have, where they have bank accounts, things like that. Now, paper account statements are pretty rare. Most are through email. And so now the personal representatives have different access as far as how to marshal your assets and where are your assets. So really, record keeping, and part of this time and everyone being home and trying to get organized, record keeping of digital assets and digital passwords is very important to allow personal representatives to gather that information in that event. Who should you appoint personal representatives? That's always a very big consideration for clients as far as appointing personal representatives. And so typically, with clients, we run through who they're close to. So whether that can be a family member, a spouse, a child, a parent, aunt, uncle, nieces, nephews. you have the leeway to name anybody that you want to be the personal representative of your estate to marshal your assets and distribute your assets after passing. And so we got family members. Otherwise, clients oftentimes want to appoint a trusted advisor, like an accountant or a financial advisor or their attorney, or banks or financial institutions do serve in roles as personal representatives. So you can appoint a corporate entity if you want. Florida does have a little caveat in that you cannot, if the person that you want to name is not a relative, then they have to be a Florida resident. So you cannot appoint your college roommate who lives in New York. You can appoint your sister that lives in New York. So any family member, wherever they live, can serve as your personal representative. But if they're not a family member, they have to be a Florida resident. So that's a little quirk in Florida as far as who to appoint as your personal representative, or who you may appoint. And the personal representative pays your taxes, your debts, your expenses, and administers your estate in accordance with your wishes. One of the other important considerations in a will is guardians for minor children. So to the extent that you have any minor children, you would put in your will, in the event something happens to you and the child's other spouse, who would be the guardian of that minor child. So that's an important consideration, even for those clients that are younger or may not think they have enough assets to really go through the estate planning process or put together a will or a trust. They would need a will if they have guardians. Now, if the children are older, 16, 17, they may have more of a say. If you don't have a will and don't appoint guardians, then older children may have a little bit of a say as far as who would be their guardian, when it comes down to the court and making that decision. But otherwise, a court would make that decision, who would be the guardian and take care of those minor children. And the last thing that families would want is certain family members having a dispute or an argument or a legal battle over who should be the guardians of a minor child. So having a will, if you have minor children, is extremely important to at least document your wishes on who you would want to be the guardian of that minor child. And then, the will, talking about collecting assets earlier and collecting mail, the personal representative and gathering their assets. Florida recently enacted something called the Digital Assets Act. So for people that have email accounts, how does the personal representative access those email accounts to know where your assets are? So that's why having your attorney or your financial advisor or your CPA, having your list of assets and where they are pretty well documented will help the personal representative's lives in a number of ways. But Florida did enact this Digital Assets Act, which allows personal representatives certain access to email accounts. There have been famous cases and legal battles over the past number of years between a personal representative of an estate and Gmail or Yahoo or Facebook in getting access to somebody's personal email or personal messages. Those internet companies always took the position of privacy is the most important, and that that they would not release certain emails or access to anyone's account, regardless of what the court says. And so there were a number of legal battles over this. Now Florida has a statute for this. You can, in your will, say the level of access that you want your personal representative to have with respect to email. You can give them full access to email. You can give them limited access. So there are certain checkpoints that we go through and questions that we go with our clients. But being organized and using this time to get organized is helpful to avoid any future confusion down the road, because it is difficult to sometimes determine where people have assets and what they have. I'll also note on that Gmail and Facebook and some of these other internet companies do now allow you to appoint, if you will, a beneficiary designation. So you can, on your Gmail account or your Facebook account, appoint somebody to have access if something were to happen to you. And so that's been helpful in this regard. And then finally, with respect to wills, updating wills for domicile planning, we've obviously seen a large influx of people moving down to Florida from the Northeast and all over the United States. Really started happening in larger numbers after Trump's tax plan went into effect a couple of years ago, which did away with certain state and local tax deductions, which increased people's taxes in New York, New Jersey, Massachusetts, any of those states in the Northeast. So we've seen clients move down, and oftentimes we talk with clients about establishing domicile in Florida so they're not taxed in their former state where they used to reside. And in domicile planning, I'm sure most people have seen there are these checklists of things that you need to do to establish your domicile in Florida, right? So you can file a declaration of domicile here in the public records, change your voter registration, change your driver's license, register your cars in Florida, apply for Florida homestead, relocate your bank that you use, change the mailing addresses on your banks and all these things, join your local Jewish federation, join your synagogue, local synagogue, other clubs, social clubs, things like that. That's the typical checklist for domicile in Florida. And one of the other items on there that you'll typically see is updating your will, update your estate planning and documents. And that's important for a couple of reasons. One, to establish domicile, your will will typically say, I, Josh Goldglantz, residing in Palm Beach County, Florida, et cetera, et cetera. So it documents that you are a resident of Florida, that you intend your estate planning documents to be governed by Florida law, and that your state be administered in Florida. So that's part of updating domicile planning. So for those people that have moved or consider moving to Florida, updating your estate planning is important. And also because since you will be a resident of Florida, you want your state administered in accordance with the laws of Florida. There are different laws. Each state has its own little quirks. I mentioned who you can appoint as personal representative, but each state has its own little quirks. So New York has some different rules than Florida. And so you want to make sure your estate planning documents are consistent with Florida law so that it's administered in accordance with your wishes. So we'll move on to revocable trust. And so I mentioned before the concept of a pour over will with a revocable trust and why this is somewhat of a new concept. And so, actually, before we go back, before I go into revocable trust, I do want to go back because I mentioned the probate process on this slide, which is important to discuss here, because oftentimes clients come to our office and they say, we want to avoid probate. We don't want probate. We want a trust. But they don't know what probate is. They've maybe listened to a webinar or a talk like this, and they've heard some negative things about probate, but they don't know what probate is. And clients just say, I want to avoid probate, but they don't understand the whole process. So when someone passes away, if you just have a will, the will disposes of any assets in your own name. And we'll talk about some caveats with beneficiary designations later. But what happens is the personal representative then takes that will, files with the court, the death certificate and the person's will, and submits it to the court and with documents requesting to be appointed the personal representative. I'm appointed personal representative in this person's will. Here's the will. Appoint me personal representative. You submit that to the court. So now the probate process is overseen by the court. And so you're unfortunately at the mercy of the court's timing, and the personal representative needs to hire a lawyer. So it's timely, and costs could get expensive depending on the type of estate. Now here in South Florida, unfortunately, Miami-Dade, Broward, and Palm Beach County are not the quickest of courts. Maybe if you're in Central Florida or other parts of Florida, the process might move a little more quickly. But here, courts are crowded, they're understaffed, so it takes a while. I can tell you that when you file the initial documents to open a probate, you're looking at probably at least a month, depending on, and obviously given with everything today, who knows, to even get the estate open. So really nothing can even happen until the personal representative is formally appointed as the personal representative by the court. So it's a process. The personal representative then has to publish what's called a notice to creditors, which is required by the court. This is a 3-month period where creditors have an opportunity to file a claim against an estate. And so you have this process that's overseen by the court, and every step along the way, you need court approval. And oftentimes now, courts, particularly in South Florida, are implementing what's called a restricted depository, where during this 3-month creditor claims period, you have to have all the assets are in a depository that's restricted. So the personal representative cannot make any distributions, cannot do anything without court approval. So the probate process can be timely. It can take some time. There are notices to be sent out, and you have to run through the steps. So that's why you hear people talking about avoiding the probate process. And when you submit a will to the court, a will is a public document. A will is public record. Anybody can see your will. So that's why in a pour over will, there isn't much disclosed there other than who your personal representatives are, who your guardians. But all it says is everything else goes to my trust. It pours into the trust. And the trust is a private document. That does not have to be submitted for record, like a will is. And so now moving on to revocable trusts, when you have this pour over will and revoke, they work together. Stable, hopefully we're okay. So revocable trusts work in conjunction with a will. So revocable trusts, and this is sort of the new way of thinking here, because this helps avoid probate. Assets titled in a revocable trust during life do not go through the probate process, and I'll get into that. So a trust is multi-purpose. It actually operates differently at different points in time. One, during the grantor's life. The person that creates the trust is the grantor. So I create my own trust. I'm the creator. I'm the trustee. I'm the beneficiary. During your life, it's as if the revocable trust doesn't exist, because during your life, you control it. You're the beneficiary. You're the trustee. There's no extra tax returns. It does not need its own tax ID. It's an alter ego of the person that created it. But the benefits are, in the event you become incapacitated and you fund assets in your trust, the successor trustee can easily take over and manage those assets for you. If you become incapacitated and you don't have a revocable trust and you do not have a durable power of attorney, which we'll talk about, then you may need a guardian appointed by the court. You may have to go through the guardianship process. And again, that is overseen by the court. So it's not cheap, and it's unfortunately not the quickest moving process. And getting a guardian appointed, then the guardian gets appointed to court approval. So we try to avoid guardianship through the court by using other means. So using a trust and using durable power of attorney. So if you become incapacitated and you have your bank account is in your trust and you're the trustee, so you can control it during your life, and then you become incapacitated, well, then your successor trustee can then come in and have access and use those funds for your benefit in the event you become incapacitated. And then upon death. So what happens upon death with your revocable trust? Then your revocable trust acts like your will, in that it says who your specific beneficiaries are and what happens to your assets. Again, you have a pour over will. So the will only says my assets go to my trust. And then the will is the specific document that disposes of those assets. Again, trusts are private, so only the beneficiaries get to see that, and they don't get to see your will. But one of the most important, where they do get to see the will, because the will is public. So benefit of a trust is you avoid probate. You can avoid ancillary probate if you own property in another state. Let's say you live here, but you still own that condo in New York or on the Jersey Shore. If that's in your own name, now you may need a probate in that state for that asset. Florida does not have jurisdiction over real estate in another state. So if you have a house or a condo in another state, that asset, you may need a probate just in that state to deal with that particular home. And that's what's called an ancillary probate. If you're a resident of Florida, but you have real estate elsewhere, the ancillary probate is in that other state. And so if that other property is titled in your revocable trust, or maybe titled some other way, you can avoid the probate in the other state. Now, your revocable trust, funding your revocable trust is one of the biggest things that people miss. One of the most common mistakes is clients come in, go to an attorney, they get their will, their pour over will, their revocable trust, they sign it, and then they go their merry way, but they didn't fund the trust during their life. Your revocable trust only is beneficial to avoid probate and to help in the event of your incapacity if you actually fund it during your life, if you change your bank account from your name into your trust name. So you do need to retitle these accounts to avoid probate. The assets will ultimately get to your trust if you don't do that, but it will go through the will. Everything will go through probate and then go into the trust. If you're trying to avoid the probate process, you want to title your assets in your trust during your lifetime. And again, you're the trustee and you're the beneficiary and you control it, but it makes it disposition easier upon death. And then typically, one of the big changes in estate planning now from historically from historical estate planning 20, 30 years ago, where most estate plans historically said, you know, upon my death, my assets get distributed to my kids, or maybe you'd have trusts for kids. But those trusts would say, okay, they get a third of it at age 25, they get a third of it at age 30, and then at age 35, they're adults, they get the whole thing outright, and then the trust goes away. They get all the assets at age 35. We advise against that structure typically for our clients for a number of reasons. We're unfortunately live in a litigious society, and assets that go outright to a beneficiary at a particular age then could potentially become exposed to their creditors, or could be exposed to a spouse if they receive their inheritance and then their spouse files for divorce a year later. I mean, what's that saying? If I had $1 for every time a client came in and complained about their son-in-law or daughter-in-law, I'd be living on a beach in Hawaii. And so the clients have those concerns about their children or grandchildren receiving their assets and having those assets exposed potentially to creditors or future ex-spouses. So we typically advise clients to keep assets in trust for their beneficiaries without requiring distributions at a particular age. The child can become their own trustee at a particular point in time. But if the assets stay in trust, there's a good chance that those assets can be protected from creditors. So if the beneficiary has a business issue, or is going through bankruptcy, or gets in a car accident and gets sued, that creditors cannot get at those assets that are in the trust for that beneficiary. Now, if you set up a revocable trust for yourself during your life, it does not help with creditors. So I'm not talking about that. I'm talking more for beneficiary. If your trust has future trusts built in for creditors, for beneficiaries, then there's creditor protection there. But your revocable trust doesn't provide you any protection there. It's really a means of probate avoidance, and having the privacy. One thing to consider: some people like the court supervision in a probate process. Some people want a judge involved. They may not trust certain family members, and so even though trustees have certain fiduciary duties to beneficiaries, there is no court supervision unless someone files something within a court. So probate has to go through court. Trusts do not. So some clients may be skittish about the lack of court supervision because they want the court supervision. But for the most part, the pour over will revocable trust combination is really, in essence, to avoid probate, to make administration easier upon death. So that's the will and the revocable trust. Now, the other three important documents, which we sometimes consider ancillary documents. And these are important because these are documents that deal with you during your lifetime. These deal with incapacity. This is not after death. Upon death, a power of attorney is void. Healthcare surrogate designation, living will, they're all void upon death. This is all during your life. And so what are the purpose of these documents? So the durable power of attorney, the intent is really to have someone make decisions on your behalf in the event you become incapacitated. But there was a big change in Florida law a couple of years ago, actually almost 10 years ago now, I think 2010 or 2011, where powers of attorney used to be called springing powers. So that would mean they would only become effective if you became incapacitated. So you would sign a power of attorney, you would appoint, let's say I appoint my spouse as my attorney, in fact, under my durable power of attorney. Your spouse would only have the powers to make decisions on your behalf if you became incapacitated. So you would need a doctor to say, you can't make these decisions, financial decisions. You're incapacitated. Someone else can make these decisions for you. Then the durable power of attorney would become effective. 9 or 10 years ago, the statute changed. Banks, financial institutions, they did not like having to figure out who was incapacitated or not. So the law was changed significantly to the point where if you now sign a durable power of attorney in Florida, they are effective immediately. The second that you sign the document, I appoint my spouse as my power of attorney. She has any powers that I give her in that power of attorney. She has those powers now, whether I'm incapacitated or not. I'm could be completely fine, and she could have those powers. So durable powers of attorney, you really need to appoint somebody that you trust. Now, to prevent against some abuse, the statute now has certain superpowers, which I put in quotes there, that can be granted, where you specifically have to initial if you want to give someone those powers. So, your durable power of attorney now has to be very specific in the powers that you're giving to that person. I give them the authority to write checks on my behalf, do banking transactions, invest my money, sign my tax returns, sign contracts. Say you get into a car accident and you're incapacitated, they can bring a lawsuit on your behalf. Essentially anything that you can do, you want to give that person the power to do, because if you don't have a power of attorney and you don't have the trust, as we discussed before, and you become incapacitated, then you have to go through guardianship, and that goes through the court. And so having a durable power of attorney avoids the court process, because somebody has those powers and that ability to make decisions on your behalf. But they can no longer be springing. So they are effective immediately. So you need to be cognizant of that. But you can limit some of the powers. The superpowers really deal with estate planning, and so really deal with gifting. So even though they can sign your tax returns and access your bank account and pay your expenses, you don't have to give them the power to make gifts, or you don't have to give them the power to deal with any estate planning documents. But you can give them certain superpowers if you specifically initial, and they have to be specifically initialed on the power of attorney, to grant those powers. And those powers are usually gifting and related to estate planning, modifying a trust, creating a trust, things like that. Those are the superpowers. But the powers of attorney are very powerful documents, but they're also very important. And then healthcare surrogate designation and living will. So now this is healthcare decisions. Who makes your healthcare decisions in the event you're unable to do so, in the event you're incapacitated? And obviously this is very relevant and very on top of people's minds today, given everything going on with COVID-19, with the coronavirus. And so this is causing a lot of people to revisit their healthcare surrogate designations and who would make those decisions on their behalf. So the healthcare surrogate designation and living will are two separate things here. Sometimes they're two separate documents, depending on the law firm. They could be two separate documents, or they could be combined into one. But the healthcare surrogate designation really is who makes your healthcare decision in the event of your incapacity. These can be what's called springing. They become effective upon incapacity, or they can be effective now. But really, obviously, if you have capacity, your doctor is going to ask you what you want. So it really comes into effect in the event you are unable to communicate to your doctor, to the hospital, your healthcare decisions, or how you want your care to go. So having a healthcare surrogate designation is extremely important in these times, given all that's going on. And a couple of things that are important to mention, given the coronavirus, we at my law firm have revised our healthcare surrogate designations to include language which allows the hospital or the doctor to communicate with your healthcare surrogate via Skype, via FaceTime, via Zoom. However, because, historically before the coronavirus, you typically think, okay, if you're in the hospital and you're incapacitated and you have a family member there that you've appointed your healthcare surrogate, they're in the hospital with you, talking to the doctor, making the decision. Now, if someone's afflicted with the coronavirus, family members are not allowed in the hospital. I mean, you hear these horror stories of people alone in their in the hospital room, and the family members can't come see them because they can't be exposed. And so we've specifically added language to our healthcare surrogate designation, which says if my family member, my healthcare surrogate, my spouse, my child cannot be in the hospital because of the coronavirus, my doctor is authorized to talk to them via Skype, via email, via phone, etc. So we want to make sure people think about these things, because this is everything going on now is really changing how we think about estate planning and healthcare surrogate designations, and a lot of this. We're also putting in our healthcare surrogate designations. We're talking to clients about experimental drugs. It wasn't as big of a topic earlier. I mean, now, obviously, you listen to the news, you watch the news, you hear all the potential different treatments for the coronavirus, none of which to this point, to my knowledge, have been approved by the FDA or the CDC. And so, you know, do you want experimental drugs to be used, even though it may not be approved by the FDA or CDC? Do you want to give your healthcare surrogate the authority to authorize use of experimental drugs that may not have been authorized yet? So we have added some of that language to our healthcare surrogate designations. And so, you know, we're, you know, something to think about for people that, you know, may want to update their documents, may want to think about who they've appointed in these roles. But that's certainly something to think about. And then your living will, most people consider the pull the plug document, if you will, right? So if you are in a terminal condition or an end stage condition, or what the statute says, persistent vegetative state, you know, do you want life prolonging procedures to be administered, or do you want those withheld? And Terry Shiva was the big case in Florida a number of years ago. And so, you know, if you are in that state and you want to document your wishes with respect to your living will, that's what the living will does. And so again, some people have the healthcare surrogate designation and living will as two separate documents. Some are combined. Either way, you know, hospitals respect these documents. This is in the statute. And so given the coronavirus and, you know, being put on ventilators, this has sort of changed people's thinking in regards to the healthcare surrogate designations and living wills. So I encourage people to revisit who they've appointed and see if they need to make any changes. One thing about these three documents, for those that have college-age students, children or grandchildren that are 18, 19, 20, everyone should have these three documents: powers of attorney, healthcare surrogate designation, and living will. You know, your child is living in another state, in college, something medically happens to them, you want to be able to provide the healthcare provider or the hospital that document that you have, and to make sure that you know, HIPAA laws are very stringent these days. You want to make sure you have access and can make certain decisions for your children if they're 18. They may not need a will or a trust, but they should have these three documents because it's very important. And so, you know, in conjunction with estate planning, I mentioned before beneficiary designations and how important beneficiary designations are. Everything I said about wills and trusts, forget it for a second, because if you have a retirement plan or life insurance policy or a checking account that has a transfer on death or pay on death beneficiary designation, if you have a specific beneficiary named on the retirement plan, that specific beneficiary is going to receive those assets. It does not matter what your will says. My will can say everything goes to my spouse. But if 15 years ago, 3 jobs ago, on my 401k, I put my sister gets everything, and I never changed that, and I pass away, my sister is going to get it. If you name that beneficiary on an IRA, 401k, life insurance, that beneficiary designation overrides, if you will, your will. And so your will, and it avoids probate, which is nice. So one way to avoid probate is also to have certain beneficiary designations. But you need to make sure your beneficiary designations are consistent with your estate planning documents. I can't tell you how many times and how many mistakes are made where people had a life insurance policy from 20 years ago, or IRA or 401k, and they named the beneficiary and they never checked it again, and they never thought about it again. And it may not be the person that they now want to be the beneficiary of that account. Maybe I'm estranged from my sister. I don't want her to receive my IRA or 401k. And, you know, it happens so often where people did not update beneficiary designations that Florida had to change their law because people would get divorced and not change their beneficiary designations. So for a number of years, there were a lot of ex-spouses receiving retirement plans and insurance from their former spouse because once they got divorced, their spouse never updated these things. Florida has now since changed their law so that if you have a 401k and you get divorced and your spouse was named, they're automatically removed. But still, it's a messy situation. You don't want to be in those situations. So you can name beneficiaries for these assets, and transfer on death, pay on death. Those are typically bank accounts or investment accounts. So it could pass directly to a person without going through probate. But you really need to make sure, I can't tell you how many times that gets messed up in people's estate plans. So that's important. Annuities, I didn't put annuities on here, but that's an important one. I'm dealing with a situation now where the person was all over the place with who owned annuities and who were the beneficiaries. That a trust owned it, but the children and the second spouse were the beneficiaries, and it's unfortunately a mess. We didn't do the estate plan. We're dealing with the mess afterwards, but beneficiary designations are so important. And if you title an asset in your trust, the trust is going to be the owner. The trust should also be the beneficiary. You don't want to have the trust as the owner and then someone else is the beneficiary. And so that's something to consider. Always talk to your financial advisor or your attorney or your accountant before updating beneficiary designations, and make sure it's consistent with your plan. Going over on time. So as I mentioned, the Secure Act, I'm going to talk about for 30 seconds. A big change in retirement plans. Essentially, the stretch IRA, where you used to be able to name a child or a grandchild as a beneficiary of an IRA, and they could take it over their life expectancy, so that the income tax deferral would continue for another 20, 30, 40 years. That has gone away. Your beneficiaries now have to take your retirement plans within 10 years. And so there are some exceptions for minors and disabled individuals, but in essence, if it's anyone other than a spouse can still roll over an IRA or a 401k into their own and get the stretch. But now there's a new 10-year rule where you have to take it out within 10 years. And then also, don't forget the Federation. Obviously, the Federation, a number of charities are doing a lot of great things right now with everything going on. And they're needed more than ever, and food banks. And it's important to make sure that if you have charitable intent, to document it and make sure it's part of your estate plan. There's some tax benefits there as far as qualified charitable distributions from retirement plans. So there's a lot of good tax planning and philanthropic benefits and things that you can do with your assets to support your local charities. So I think I'm done here. Anyone want to? I guess we'll see how we can get some questions if anyone has any. And Erica or Stacy, I'm not. Should I take off my stop sharing? Okay.
It's okay. Does anybody have any questions? You can use the raise hand.
Yeah, I see a raised hand. So it looks like Kathy Schwartz. How do I?
So Josh, can you hear me?
Yes.
Could you just explain for everyone how the QCD from the retirement assets works? What's the benefit and who might consider that as a planning tool?
Yeah, so the QCD is the qualified charitable distribution from a retirement plan. Essentially, a participant can distribute up to $100,000 from their retirement plan. If you're required to take your minimum distributions, which have now been raised from 70 and a half to the age 72, but if you're required to take a minimum distribution, you can have up to 100,000 every year go directly to the charity of your choice. It counts as your distribution from a qualified distribution, a minimum distribution from your IRA. So it counts against that, but you're not taxed on it, and it goes directly to the charity. So it's a win-win in avoiding a tax on that amount and benefiting your favorite charity. And so that's been in effect for a while, and that was kept in effect in the Secure Act. So that's still ongoing. So that's been allowed for at least 5 or 6 years now, and it's certainly a great benefit for those that are required to take a minimum distribution from their retirement plan and want to help out their charity.
Anyone else has any questions? You can just unmute yourself and just ask the question if you don't know how to do the raise hand.
And I know this was a lot of information and I kind of ran through it fast, but certainly I think everyone will have my contact information. Anyone can reach out to me at any point. I'm happy to answer any questions that anyone may have with respect to any of this.
Okay, well, if there's no further questions, thank you, Josh, for taking the time to be with us today.
Absolutely.
The information you gave us is important during normal times, but now during this health crisis, it's even more essential that we all have our ducks in a row. And thank you to everyone else for joining us. Look for an email from us with more ways to connect with your federation and our Jewish community during these unprecedented times. Stay safe and be well. Thank you, everyone.
Thanks.